I can jump in on the MRTMA question, marijuana question that was asked in the Q&A. Thank you, Robert, for that question. The question is whether there's any way to determine licensing under MRTMA that won't result in litigation, because it seems like every time a community opts in, they get sued. And I appreciate that question. I think where we most often see litigation by unsuccessful applicants is where the number of licenses is limited. But often, I guess the best way to protect against that, because if you do have a limited number and you have more people that want them and don't get them, the unhappy people, marijuana businesses are generally well funded. They do have a tendency to litigate. You really want to make sure your process is right. That starts with the language of your ordinance, making sure that it complies with the statute, and then making sure that that process is followed, because the unhappy or unsuccessful applicant will always try to attack the process, that you didn't follow this, your ordinance didn't comply with that. If it's just a matter of the township had the right process, it had a lawful ordinance, it followed that ordinance, and it just reached a decision that this applicant doesn't like, then that applicant is not going to be very likely to succeed in a challenge of that. So far in our experience in representing municipalities that have been challenged, the courts are not inclined to rescore applicants or make a different decision as to which applicant is best. Where there's more vulnerability is in the process. So that would be my recommendation, is to make sure you've got a strong ordinance and make sure you're carefully following both your ordinance and the statute. Communities that don't limit the number of licenses have less litigation because you don't have that competition, you don't have unsuccessful applicants, but not all communities obviously want to have an unlimited number of marijuana businesses.
So Laura, we've got another question for you, asking about, talking about regulating medical marijuana through zoning.
Great.
If you could address that.
Sure, I can do that. That question is from Bill Sutherland. Hi, Bill. Thanks for asking that. So before I was talking about marijuana businesses, retailers, growers, commercial operations, I think your question is talking about caregivers under the original 2008 Medical Marijuana Act, where they're not the commercial business. This is the people who are limited to 72 plants, limited in the number. And you are correct that the township cannot prohibit patients and caregivers, but that the township may regulate them through zoning. There was a case that came out that affirmed townships and municipalities' ability to do that. So you could, for example, zone on at least a forward-going basis where caregivers can operate and reasonable time, manner, and place restrictions for that. So you are correct that you cannot prohibit patients and caregivers. You can, of course, still prohibit both medical and adult use commercial businesses, and you can regulate all of it through zoning now. There's a question from Deb on, it says, could you provide examples of competitive processes when deciding who receives licenses for adult use marijuana businesses? And that's a great question. The statute doesn't tell us what that competitive process needs to look like. It just tells us that you have to have a competitive process if you are limiting the number of licenses. The standard is that you're determining which applicant is best suited to operate in compliance with MRTMA, the statute, in your municipality. So that raises a couple of, oops, I just froze. Okay, there we go. One is whether the person is suited to operate in compliance with the law, and then or best suited to operate in compliance with the law in this particular community. So what we typically do, depending on how the township wants to approach it, is develop some criteria that we put right in the ordinance for the township board, or if they're designating a committee to decide these applications, whoever the decision maker will be, they will have criteria to apply that directly relate back to that statutory standard. So factors that go into whether they're well suited to operate in compliance with the law in the township might be, have they run a marijuana business before? Do they have a history of violations either with the state or in other communities or in this township? What is their business plan? What is their plan for a number of employees? Are they going to be staffed well enough to meet all of the many requirements under state law and likely under the township's ordinance for operating a marijuana business? So we put those standards in so that it's not just a matter typically of the township just saying this one seems more best suited, right? Because going back to what I said earlier, we want the process to be as impeccable and as fair and transparent and competitive as possible, both because that's what the statute requires, and to ensure that if the township's decision is challenged later, that the process has been very clear from the outset. So that competitive process is not going to look identical in every township. It's going to depend on the community's needs, but generally that's an example of some of the factors that a township might consider including.